Hello and welcome to Legal Bachit. Today, we are exploring a pivotal section of a landmark legislation in Indian financial law, Section 14 of the Insolvency and Bankruptcy Code, 2016. Introduction to Section 14. Section 14 stands at the heart of corporate insolvency proceedings in India. It's a section that significantly influences how insolvency resolutions are approached, making it a vital area of understanding for professionals and students alike. Overview of the Insolvency and Bankruptcy Code. The Insolvency and Bankruptcy Code, introduced in 2016, transformed the landscape of insolvency and bankruptcy in India. It streamlined the process, aimed at quicker resolutions, and sought to protect the interests of various stakeholders involved in a distressed business. Importance of understanding Section 14. In this episode, we'll dive deep into Section 14, unraveling its clauses, implications, and the significant role it plays in the insolvency process. We'll also look at how it affects creditors, debtors, and the overall business environment. Let's read Section 14 of the Insolvency and Bankruptcy Code, 2016. On the insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following, namely, a. The institution of suits or continuation of pending suits or proceedings against the corporate debtor including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or other authority. B. Transferring, encumbering, alienating or disposing of by the corporate debtor any of its assets or any legal right or beneficial interest therein. C. Any action to foreclose, recover or enforce any security interest created by the corporate debtor in respect of its property including any action under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, 2002. D. The recovery of any property by an owner or lessor where such property is occupied by or in the possession of the corporate debtor. Introduction to Moratorium. At its heart, Section 14 establishes a moratorium. This is a legal pause on all proceedings against a corporate debtor. It includes stopping lawsuits, preventing the transfer or disposal of assets, and halting the enforcement of security interests. Implications of the moratorium. The moratorium is designed to give the corporate debtor space to restructure without external pressures. It's a critical period that prevents creditors from dismantling the debtor's assets, ensuring a coordinated approach to insolvency resolution. However, the moratorium doesn't mean a complete halt of all activities. Essential services continue, and certain transactions can still occur, as specified in the code. The moratorium also has exceptions, as it doesn't apply to certain transactions and agreements. Understanding these nuances is key. The moratorium aims to balance the interests of the corporate debtor and its creditors, providing a structured environment for resolving insolvency. Detailed analysis of provisions. Analysis of Clause A. Clause A of Section 14 stops the institution or continuation of any legal proceedings against the corporate debtor. For example, if a company is undergoing insolvency proceedings, any ongoing lawsuit for debt recovery must be halted. This provision ensures the company isn't burdened with additional legal challenges during this critical period. Analysis of Clause B. Clause B prohibits the corporate debtor from transferring or disposing of its assets. Imagine a scenario where a company, on the verge of insolvency, starts selling its assets to select creditors. This clause prevents such actions, ensuring fair treatment of all creditors. Analysis of Clause C. Under Clause C, actions to enforce any security interest over the debtor's property are halted. This means, for instance, that a bank cannot seize property of a company in insolvency proceedings for loan recovery. It's a measure to prevent the dismantling of the debtor's assets during the moratorium. Analysis of Clause D. Clause D relates to the recovery of property by an owner or lessor from a corporate debtor. For example, if a company in insolvency is using leased equipment, the lessor cannot reclaim this equipment during the moratorium. This provision helps the company maintain its operational capacity. Explanation of the moratorium's scope. The moratorium also includes an explanation clarifying that licenses, permits, and other grants are not to be terminated due to insolvency, provided there's no default in current dues. This means a company can continue its operations using its existing licenses and permits during the moratorium period. Analysis of subsections 2 and 2A. Subsections 2 and 2A ensure that essential goods or services to the corporate debtor are not terminated. This is crucial for the company to continue its operations and potentially recover. For instance, utilities like electricity or water cannot be cut off, which is vital for companies in manufacturing. Analysis of Subsection 3. Subsection 3 outlines exceptions to the moratorium. It specifies that the moratorium does not apply to certain transactions, agreements, or arrangements. This means there are specific scenarios where legal actions can still proceed, ensuring that the moratorium is not misused. Analysis of subsection 4. Finally, subsection 4 clarifies the duration of the moratorium. It remains in effect from the order date until the end of the corporate insolvency resolution process, unless a resolution plan is approved or a liquidation order is passed. This sets a clear timeline for the moratorium's applicability. Case law interpretations. Indian Overseas Bank vs. Arvind Kumar. In the NCLAT order dated 28.08.2020, it was clarified that a performance bank guarantee does not fall under the purview of Section 14. This means that even during the moratorium, such guarantees can be invoked. This interpretation ensures that performance-related obligations remain enforceable, maintaining business accountability. SBI vs. Debashish Nanda. The NCLAT order dated the 27th of April 2018 highlighted that funds deposited in the account of a corporate debtor cannot be appropriated by banks towards their own dues during the moratorium. This ruling protects the operational liquidity of the corporate debtor, ensuring that funds meant for day-to-day operations aren't diverted. Sirpur Paper Mills Limited, VSIK Merchants Private Limited. A High Court order dated the 10th of January 2020 stated that once the moratorium period is over, there's no further embargo on other proceedings and suits. This case underscores the temporary nature of the moratorium, emphasizing that legal actions can resume post-moratorium. Videocon Industries Limited vs. SBI and Oz. In the NCLT order dated 13.03.2019, it was determined that Profit Petroleum is covered under Section 14. This broadens the scope of the moratorium to include specific types of revenue, ensuring that a company's essential revenue streams are protected during insolvency proceedings. Canara Bank vs. Deccan Chronicle Holdings Limited. The NCLAT order dated the 14th of September 2017 clarified that the moratorium does not affect proceedings under Article 32 or orders passed under Article 136 of the Constitution. This interpretation ensures that constitutional remedies remain accessible, even during the moratorium. RBL Bank Limited vs. MBL Infrastructure Limited. An NCLT order dated the 18th of December 2017 stated that guarantees cannot be invoked during the moratorium period. This protects the corporate debtor from additional financial burdens during the restructuring process, ensuring a focus on resolution rather than litigation. Anju Agrawal vs. BSE and Oz. The NCLAT order dated the 2nd of April 2019 established that Section 14 prevails over Section 28A of the SEBI Act, 1992. SEBI cannot recover any amount, including penalties, from the corporate debtor during the moratorium. This ruling highlights the supremacy of the Insolvency Code in insolvency matters. Haravtar Singh Arora vs. Punjab National Bank and Oz. According to the NCLAT order dated 20.09.2018, all proceedings before any court must halt once the moratorium period starts. This reinforces the comprehensive nature of the moratorium, ensuring complete legal protection for the corporate debtor. Alpha and Omega Diagnostics, India, Limited. vs. Arkell and Oz. The NCLAT order dated the 31st of July 2017 stated that the moratorium prohibits any action to recover or enforce security interests created by the corporate debtor. This ruling is crucial in safeguarding the assets of the debtor during the moratorium. Alchemist Asset Reconstruction Company Limited. VS Hotel Godawan Private Limited. The Supreme Court order dated the 23rd of October 2017 clarified that the moratorium under Section 14(1)(a) expressly interdicts the institution or continuation of pending suits or proceedings against the corporate debtor. This ruling underscores the comprehensive legal protection provided to debtors under the moratorium. P. Mohanraj vs. Shah Brothers Ispat Private Limited. Finally, the Supreme Court order dated the 1st of March 2021 established that Section 14 covers proceedings under Section 138 of the Negotiable Instruments Act, 1881. This expands the moratorium's reach to include proceedings related to bounced checks, further protecting the corporate debtor's interests. Impact and implications. Impact on creditors. Section 14 significantly impacts creditors. It restricts their ability to initiate or continue legal proceedings, enforce security interests, or recover debts during the moratorium. This can delay debt recovery but also encourages creditors to participate constructively in the insolvency resolution process, aiming for a viable restructuring plan. Effect on debtors. For debtors, Section 14 provides a critical respite. It allows them breathing space to reorganize without the immediate threat of legal actions, asset seizures, or disruptive creditor actions. This period is vital for formulating a resolution plan that could potentially save the business from liquidation. Influence on the insolvency process. Overall, Section 14 plays a balancing role in the insolvency process. It ensures that the corporate debtor's assets are not prematurely dismantled and provides a structured environment for fair and orderly debt resolution. However, it also poses challenges, such as potential delays in the resolution process and the risk of abuse by debtors seeking to evade legitimate claims. Recent amendments and their significance. Recent amendments to the Insolvency and Bankruptcy Code have further refined Section 14. Notably, the introduction of subsections 2A and 3 have clarified the scope of the moratorium. Subsection 2A emphasizes the importance of maintaining critical supplies to the debtor, ensuring operational continuity. Subsection 3 outlines specific exceptions to the moratorium, preventing its misuse and ensuring that certain essential transactions can proceed. These amendments aim to make the insolvency process more efficient and equitable for all parties involved. Summarizing key insights. To recap, we've explored the nuances of Section 14 of the Insolvency and Bankruptcy Code, 2016. We delved into its clauses, the concept of moratorium, case law interpretations, and its impact on creditors, debtors, and the insolvency process. The key takeaway is the balancing act Section 14 performs, protecting corporate debtors while maintaining a fair process for creditors. In my view, Section 14 is a critical tool for managing corporate insolvency, though it's not without its challenges. It effectively pauses the financial pressures on a struggling company, but it can also lead to delays and potential misuse. Looking ahead, we might see further refinements to ensure that the moratorium serves its purpose without unintended consequences. What are your thoughts on Section 14? Do share in the comments below. And if you found this analysis helpful, please like, share, and subscribe to Legal Budget for more insightful legal breakdowns. Thank you for watching. Your engagement and feedback make this channel a rich resource for legal enthusiasts. Stay tuned for more content on legal and financial topics that matter to you. Until next time, keep analyzing and stay informed.